Welcome to EUPrivacyForAll, Session 15 on GDPR, Processing Not Requiring Identification, Article 10. Negotiations going on in the frame of Article 10 enhance the fact that European Parliament and EU Council had quite the same approach. No need to process data that would be identifying directly or indirectly a data subject if it is not needed for the processing. In case the data subject would like to exercise a specific right, then it would be in capacity to provide additional data. In the final draft of Article 10, it is stressed that the controller shall not be obliged to maintain, acquire or process additional information just in order to allow a data subject to potentially exercise its right. The data subject, however, can provide additional information in order to exercise those rights. Recital 23 brings three added values. First, knowing that data protection will apply only to identified or identifiable natural person. Pseudonymized data are part of the scope of identifiable data. Second, whenever it is assessed whether a set of data is identifiable or not, all the means reasonably likely to be used shall be assessed, including costs, amount of time required for identification based on available technology at the time or technological development. Finally, principles of data protection should not apply to anonymous information. However, today it remains quite challenging knowing what is anonymous information. Other provisions in GDPR, such as Recital 45, bring additional insight on what is identification. So, identified data could result from digital identification based on authentication mechanism using credentials or login information. The controller also has the obligation, when further processing data for archiving, scientific, historical, or statistical purposes, to assess the feasibility of such processing using data that will not permit or no longer permit the identification of data subjects. Finally, Article 4.1 provides the definition of personal data. It means any information relating to an identified or identifiable natural person. Article 5.1 of GDPR reminds something that was already laid down in the directive. Personal data must be kept in a form which permits identification no longer than is necessary for the purposes. Article 83 on derogations and safeguards regarding archiving scientific, historical or statistical purposes also outlines the fact that appropriate safeguards should be used based on technical and organizational measures to respect the principle of data minimization. Among those measures, pseudonymization is a key one. Whenever these purposes can be fulfilled by further processing of data which does not permit or not any longer permits the identification of data subjects, these purposes shall be fulfilled in this manner, in a de-identified way. The directive applies to any information concerning an identified or identifiable person. To determine whether a person is identifiable or not, account should be taken of all the means likely reasonably to be used. Additionally, codes of conduct, framed by Article 27 of the directive, could be used to give guidance on the ways that could be used to render data anonymous. definition of personal data, and the fact that it shall not be kept in a way that would allow identification of a person longer than necessary is also laid down in the directive. What should accountable data controllers and processors get prepared for? First, sticking to the core principle laid down in the directive, stressing that all information directly or indirectly allowing to identify persons fall within the scope of the regulation. Second, taking due count of the fact that the identification of data subjects shall not be longer than necessary. Refraining from maintaining, acquiring, or processing additional information just for the data subject to be in capacity to exercise their rights. In such a case, data subject would specifically provide additional information. De-identified data whenever it is possible, notably using pseudonymization mechanisms. Bear in mind that identification number or online identifier enters the scope of processing information related to identifiable persons. Finally, assess rigorously whether a person is identifiable or not, taking account of two things. First, all the means reasonably likely to be used, depending on technology at the time of the processing, and then costs and amount of time required. EDPB guidance will be more than welcome on knowing how to differentiate what is still identifiable data and what is anonymized data.